Good morning, everybody. It's great to be here, and thank you for Professor Engstrom for that wonderful keynote. I'm Harry Certain. I'm a professor of law at the University of Colorado and also associate director here at Stanford's CodeX Center. And I want to start out by thanking Roland Vogel, our fearless leader, who is a visionary, and he's been working tirelessly for over 20 years to build the incredible CodeX and FutureLaw community that we all benefit from today. So none of us would be here without the leadership and hard work of Roland Vogel. We have an incredible panel joining us today. They have very impressive bios, but in the interest of time, I will only briefly introduce them. To my left is Judge Erica Yu, who until recently was Superior Court Judge in Santa Clara and is now CEO of the American Leadership Forum in Silicon Valley. And she has thought a great deal about evidence in the AI era. Next to Judge Yu is Judge Yvonne Campos of the Superior Court of California in San Diego, who's a well-known thinker and commentator on AI issues, both within the criminal docket and outside, and is one of the real leaders in this area. And last but not least is Shlomo Clapper, the founder and CEO of Learned Hand, an AI platform specifically built for courts designed to improve reliability and accuracy in law. So today we're going to look at AI use in the courtroom from three different perspectives: AI used by judges, AI used by lawyers, and AI used by the parties themselves. And as we heard from the keynote from Professor Engstrom and Natalie, AI promises to bring immense benefits. This can include more efficiency for judges in reducing backlogs in dockets, potentially higher quality legal arguments from lawyers due to better research and more sophisticated arguments, higher quality overall work product, and importantly, legal assistance to self-represented litigants. So there's huge promise of AI in the courtroom. And a recent survey just showed that over 60% of federal judges indicated that at least once they've used AI in their courtroom work. Yet AI also comes with many perils. We've all heard of the various lawyers who have submitted briefs with hallucinated citations or hallucinated holdings. At the moment, there are at least 1,000 such incidents on the record, and there's probably more. We've also may have heard of the federal judges who recently released orders with hallucinated federal cases. And then we also are now hearing incidents where litigants are using AI-generated filings and discovery filings in an attempt to overwhelm the opposition. In the past, it was not possible to generate filings and documents at such a volume. And an important issue, which we'll talk about today, is deepfake evidence. And this creates two problems. Of course, the issue is AI-generated video evidence purporting to be genuine, and the converse, which is genuine evidence that lawyers and litigants are accusing of being deepfakes, thereby undermining the trust in the evidentiary systems. So both the promise of AI and its perils in the courtroom are the focus of today's panel. So my first question will be for Judge Campos. So Judge Campos, where are we actually seeing AI use in chambers right now? Where is it proving genuinely helpful? And where do you see the greatest risks of AI in the courtroom?
All right. Thank you, Harry. Thank you, CodeX, for inviting me, and thank you all for attending. Can I see a show of hands of anyone that thinks that lawyers are risk averse? All right. I see some hands. Multiply that by a factor of 10 for judges. I'm going to comment briefly on two systems. The state court system, which in California I'm familiar with, but which every single state and all of our territories have their own independent court systems. And then, of course, the unified federal system. And there's two different worlds. The federal system is substantially better resourced than state court systems, even in an abundant state like California. We're not early adopters as judges. COVID hit, and the only reason that we started doing hybrid proceedings where people could MS Teams in or Zoom in was because COVID forced us to. And it was painful, and there are still complaints and hiccups, but that was something that was forced on us, and that's the only way we got to where we are now. I want to share with you and have you think of the context of the profession for hundreds of years used a quill, pen, and ink. If you argue before the United States Supreme Court, you still get, as a memento, a quill pen. No ink, but the quill pen. Then we went to typewriters. Then we went to computers. When I was a law student, I had to teach people how to shepherdize the old way, meaning books. And Boolean searches for Westlaw and Lexis were just coming up. All right. I surveyed some of my state colleagues, and I let them know that it would be confidential and anonymized. And I was actually thrilled with some of the responses that I got. I practically got about a 10 to 12% response rate of my bench of 135. I think I only heard from one of our commissioners. We would have a couple dozen of those. Those are subordinate judicial officers. I think the rest of them, nobody wants to touch it because judges are getting in trouble. For the lawyers in the room, I'm going to mention two cases, but I'm only going to give you one citation. I was thrilled that my colleagues on the state court bench have moved in the past year from absolutely not touching it, to, oh, I'm trying a few things. And my court did pay for co-counsel, and we've had some varying experiences. Now, on the seniority list in my court, I'm 16th, and I've been on the job almost 23 years. We've had a revolution of retirements, and many of my colleagues have less than 5 years on the bench. So generationally, we're talking about people, maybe 20 years younger, not necessarily. Both this governor and the last appointed someone to the bench at age 70. Take that for what it's worth, but I give you all of that as context. Now, my colleagues professionally are doing the things that you might expect. They're starting to use either co-counsel or co-pilot because we have the Microsoft suite of items. They're writing orders, they're summarizing testimony, they're doing legal research. Some tell me they haven't figured out how to use it. Some tell me that they are using Claude for math to help them check the math on child support orders because they think that it's really good at math and they want something quick and dirty. Some of them are telling me that they're still using Gemini or GPT for quick legal research because of the 10 minutes that it's taking Claude to give them an answer. They don't have that kind of time, real time, with the heavy docket and lots of people in front of you in court. Things have to go. When people used to ask me, how many cases do you hear a day? It could go from 1 to 130, okay? And when I have 130 or over 100 matters in the morning and I do the math, I've got less than 90 seconds per case, okay? That is the state court system. If you watch the pit, the trial courts in the state are the ERs of the legal profession, okay? Now, on what else are they using it for? One of my colleagues who wants everyone to know he's not a Luddite, but he consciously doesn't use anything with AI. He's annoyed that he has to try to turn it off on his other products. And he has that point of view because he had co-counsel give him something that was dead wrong, and therefore he's not going back. And that was a sentiment from a few other colleagues. This particular colleague wanted me to know that he had built a Linux server from scratch. Okay? So he doesn't want to be known as a Luddite. I have a colleague who's a Marine Corps reservist in the JAG Corps. He said that throughout the Marine Corps, they encourage everyone to use it at all levels whenever possible, and he used a lot of Gemini with the Marines. Okay? And then people have told me they don't want the algorithms leaking stuff about them for free. They very much want to own their own prompts and whatever it is they're doing. And then the point about not having 10 minutes to wait for Westlaw research or things of that sort came up more than once. And I think that's about it. And I think that one of my leading friends across the street in federal court, U.S. Magistrate Judge Ali Goddard, who's been teaching federal judges all over about this. She's using it in her chambers. She uses it for settlement conferences. She uses it for all sorts of things. And she's a big Claude devotee. Personally, how my colleagues are using it is, I was surprised. Some of them are having it design their gardens. It's selecting their plants. One of my colleagues is having it pick her makeup shades. Others are using it weekly for dinner and shopping lists, something that can be made in less than 30 minutes. And one of them had it find her a new microwave that could also work as an air fryer. And she calls her AI her new bestie. Travel itineraries, creating stories with a grandchild, workout plan came up a few times. And the court, as I said, provides us with Copilot through Microsoft and Westlaw Co-Counsel. I know that other courts are doing different things. I hope you heard about the LA projects with Stanford Law School and Professor Engstrom, who was here. Orange County Court made some internal chatbots as they're using to train their court personnel, and they found that that's been great. And then my court is not doing anything of that sort because my IT staff is working 24/7 to help our criminal division migrate from paper case files with triplicate forms that clerks were still filling out with pen and paper, but had moved up to filling them out with the computer. And it's causing a lot of havoc. It's causing a lot of angst. And so I'm in a world on a daily basis of hybrid. I've got a Tyler Odyssey product on a screen. I've got case files coming at me. It's a mishmash. It's a mess. It's not seamless. And so that's the world I'm coming from. 2 cases I want you all to know because it freaked me out and it freaked out my colleagues. The first is from the Sixth Circuit. You've probably heard of the United States versus John C. Ferris case. This is a case where the lawyer did cite real cases and he did use co-counsel. And I don't want to bag on co-counsel because I love them and I've used it and it's great. Stop, Shlomo. I'm not here to advertise your product. I can't advertise anything, right? I can't give any likes. U.S. versus John C. Ferris, real cases cited in briefing, but it made up quotes within those cases. The quotes it made up were not in the cases. So the Sixth Circuit reprimanded the lawyer, undid the results, gave the defendant a new appellate counsel for his criminal appeal, and that made me think twice because I hadn't clued in on the fact that it was making as many mistakes as I'm learning it makes. Second case, one of my colleagues in San Diego, the case of In Re Domestic Partnership, Torres Campos versus Munoz. No relation. That one is at 118 Calap 5th, 1112. And it's a March 2026 case. And my local appellate court, in a dog custody matter, took my colleague, the judge, to task because the 2 lawyers in the case agreed upon a proposed order after her ruling, and they submitted an order that in family court, where the judges are just drowning daily. I routinely see one of my colleagues' cars in the parking lot past 9 p.m. She had just signed it, and she didn't read or check on whatever they cited because the lawyers agreed, okay? But this case, aside from telling lawyers, you got to see what your opposing counsel is doing, and you better call them out. If they're misusing AI or if there's bad cites, they called out the judge on this one. So that one's frankly terrifying because we don't have time to do that.
Okay, thank you, Judge Campos. It's just to reframe some of the themes I'm hearing, widespread but tentative use in the state courts and rather ad hoc rather than systemic. Let me ask the same question to Judge Yu.
Yeah, so rather than look at sort of more microcosms, I'd like to speak on a broader level, national level. Until I retired on January 23rd and then became the CEO on February 1st, I was on the National Center for State Courts Board. The National Center really is a leader in terms of AI adoption by the courts. And this is really unique because the courts have often been as Judge Campos said, slow adopters, behind the curve. For example, with language access, California had to be sued by the Department of Justice before it really looked at language access. The courts have not really dealt with overrepresentation of certain population incarcerated in our jails and prisons. But the National Center decided to start a consortium with Thomson Reuters and has been a leader in court and court staff adoption in AI. If you Google National Center Consortium AI, it takes you to this really great website where there's multiple webinars that we've provided. There are different veins of education for judges to use AI, including a sandbox for judges to practice using it. There's education for court staff, because really courts in adopting AI can find the most value, I think, in terms of administration and court staff. It is more difficult for judges because there's a lack of trust by the public that the court's going to supplant the AI to make the decision, and that's not going to happen, and I'll address that. But in terms of automation, moving data, understanding backlogs, as Harry mentioned, that is really, I think, a growing area for courts in the adoption of AI, so that administration and court staff. And so I would tell you, as people interested in the law or people who are actually practicing, to go to that website. There's so many tools there, including bench cards, which I'll talk about when I talk about deepfake evidence. With respect to judges using it, I think that almost now every Supreme Court or Judicial Council has some guidance for courts. In September of last year, California's Judicial Council adopted a rule of court and a standard of administration that guides judges, court staff on the use of AI, which really centers on not having any bias come into the, work product, and then also making sure that there's disclosure. The California State Bar and other bar associations around the country, including the ABA, have standards for lawyers about the adoption of AI. And what's interesting is it's disclosure, confidentiality, which you would expect, but also talks about communication with the client, the ABA standards talk about letting the client know what the use is going to be and what the benefits will be. And I think what's going to be interesting for people who are practicing is, what's the fee structure going to be, right? I mean, if it's going to take you less time to do an AI type search, how will that impact the fees? But interestingly, I think in terms of the hallucinated cases that Judge Campos talked about and Harry talked about, I think that will be less and less of a problem for us, because as you'll talk about, Shlomo, the AI tools are going to be more and more case specific, more and more specific to the area of practice. And there will always be a human in the loop, but nationally, we're really thinking of it more as human in charge. I think if courts will have the time and they're going to need to change the way we practice, we're going to have to get maybe more law clerks or more interns just to spend the time to check citations provided by attorneys who agree. We will be able to figure out the hallucinated piece. And when we talk about deep fakes, the human in charge or human in the loop is almost going to be worthless, because the technology is going to be so good that the evidence is going to be so difficult to parse out. And so we'll have to talk more about experts and things like that when we get to that topic. But I think nationally, there's a lot of tools for judges and court staff to use and adopt AI in a way that makes sense, that is cognizant of the potential hazards that we will continue to talk about in this panel.
Thank you, Judge Yu. That's a really helpful perspective from the national level. Let me turn to Shlomo. So we referred to the two cases, Wingate and Neal, where the federal judges released orders with hallucinated cases. By the way, they blamed it on their law clerks, who said the law clerks use general purpose tools like ChatGPT to create it rather than specialized legal tools. But speaking of specialized legal tools, Shlomo, you've been working on a tool that helps courts improve the accuracy and citation checks. Can you say a little bit more about these tools generally, and more broadly, how do we improve this problem? It seems like a solvable problem. How do we make it so these systems can be reliable both for the judges and the public?
Yeah, absolutely, Harry. Well, first off, I wanted to join the chorus of people thanking Roland for inviting me, and also for putting on the best. This is the best conference in legal tech, and also where I 2 years ago I started the company right around here. So I just met Judge Campos, met Bridget, and Pablo, reconnected with Pablo. So it's coming full circle. So I want to talk about 4 things real quick. Number one is I think Judge Campos very evocatively talked about the problems of courts. I want to add a few more statistics. Then I want to talk about what the alternatives are for courts. And then I'll talk a little bit about how we address this problem and build specifically for courts. And then I talk about, like, what is the end? Like, what if we have AGI? Eric, you talked about that we're not going to replace judges. But I want to ask the uncomfortable question of why not? And I also think we're not going to replace judges. I actually think, even from an AI perspective, I really don't. We want to have human-computer symbiosis. But
I actually think we can in certain case types.
oh, so
I too believe in robo-judge.
oh man, I'm the conservative on the panel. I'm the reactionary. Okay, so the first thing about the problems. So is Professor Engstrom still here? I can't see him, but
Busy man.
He's a busy man. He talked about, will we allow states to allow lawyers to practice without, allow people to practice law without being lawyers? In 22 of the states of this country, you can be a judge without being a lawyer. 90% of judges do not have clerks. They're doing all the work themselves. 8 out of 10 hearings are delayed. In state courts, 9 out of 10 judges work overtime. There's rates of burnout on the level of war veterans from judges. The state of the American justice system is in crisis. Even in the federal courts, there has been, since 2004, a 346% increase in the number of filings. So that's 4.5 times, just like the number of filings in the federal court system, with a 0% increase in the number of federal judges. President Biden vetoed the Judges Act that was signed and passed in a bipartisan way before he left office. So the system is drowning, but there's one thing that is the looming over the court system, which is all the legal tech companies that have come out of Stanford and the Bay Area. There's something called Jevons paradox, that as the cost of something, price goes down, quantity goes up. So we are already seeing in the last 2 years a stark increase in the amount of litigation. Apparently the bulwark of the American legal profession somehow prices out 90% of the cases. So we have an access to justice problem, but that's being solved by Claude and ChatGPT, basically allowing people to be able to do legal work. There are going to be new models of legal delivery, but that's going to be a fantastic thing for American justice. But think about the second order effects on the court system, right? If we actually have access to justice, the court system will be overwhelmed by the amount of cases. So that something needs to change. And what needs to change is that I don't think we need to replace judges. I think we need to give judges technological leverage so that the same amount of judges can do more judging, and in my view, even better quality judging. So that's our goal here that I started learning at hand around. I was a law clerk myself. I worked at Palantir, so I've been able to see both sides of this. And in essence, we built a tool that has three special qualities. Number one, in terms of quality, judges are very busy. They don't have a lot of time. They essentially need something that can do the work. Generative AI generally is pretty good at summarizing and creating timelines. And we just announced our work with the LA Superior Court. And internally, they have tools, AI tools that do summaries and timelines, and it's very good. But they're not doing something that's touching the analysis. And that's where we at Learn at Hand go into the hardest part, which is the actual work of judging, so that a judge can, or a law clerk or a staff attorney can have an additional, essentially digital labor in the courts. So that's the first thing. And so we have a very relentless focus on high quality. The second is neutrality, is that LLMs are sycophantic. you ask Claude two opposing things, and it says both a fantastic idea. What a wonderful idea! And it gives it's uncertain. With judges, you can't do that. By the way, that's a great fit for lawyers, because what you need to do is advocate for your client, but for judges need to find the truth. So to architect a system that's focused on finding the truth rather than bending the truth. The third thing is in terms of accuracy, because if we have, co-counsel can have hallucinations, but still is going to be around, right? And if we have one, I'm going to be looking for a job. So we have a very robust system that pre-verifies everything before it goes to the judge, so that you don't have to spend time tracing down, running down these hallucinations, which are very, very tough to catch. The last thing I'll say is in terms of one of the things that I've shifted a lot in AI has shifted in the last year since the last conference. One of the things that's shifted in my company is we've gone from trying to convince judges that this is actually going to help them, and it's shifted much more towards this is going to make junior judges like dumb. They're not going to be able to learn. They're going to things the same questions that people have about upskilling. So I think that in some ways that's good because people are seeing the value of the tool. But I think the question is, when we're thinking in the long run, like what do we want AI in the court to do? And if people are really interested in this topic, I wrote a 200-page article about it that is FDA approved for sleep problems. Right? You read it goes straight to sleep. But I call it the difference between epistemic and constitutive tasks. There are some tasks that judges do that are purely epistemic, that are trying to find information, that you're trying to figure out whether something is a disputed fact or not, whether you're looking up case law. The question is, will more information help? Or there are some parts where you're actually playing a political constitutive role where there's no right answer, but the judge is making an action, a judgment, and then that is the right answer. It's like collapsing the superposition on quantum physics. Like once you collapse it, that is the correct answer. I think a lot of criminal, whether you're sentencing somebody to how long is the sentence, family law, parental rights, those are decisions. It's not about, low value versus high complexity. It's not about that. It's about the nature of the proceeding itself. And in my view, each judge has his or her own Jarvis from Iron Man rather than a legal Skynet. And anyway, so that's my perspective as a technologist, and happy to talk more.
Thank you, Shlomo. That was very interesting. What I'm hearing is the future of the courts are 3-judge panels of ChatGPT, Claude, and Gemini.
Heaven help us.
Yes. So let me turn this to the judge. And I heard you mention, Judge Yu, that you don't believe it will be a problem of AI influencing the outcome of judges. Can you say a little bit more about something I've written about it? Is the way current LLMs work. They inject things in the background, whether it's Claude Code's principles or system prompts or things like that, or your own memories, which can subtly influence the outcomes, and they're also stochastic rather than deterministic. So how do we guard against the LLMs pursuing one stochastic path and producing an outcome that might not be what the judge would have thought had they not used the AI at all?
Mm-hmm. So this kind of dovetails to what I commented and interrupted Shlomo, and I apologize when I said that I think that we can replace judges in certain case types. So, for example, why does someone have to serve as a bench officer in a traffic court setting, right? Because that's sort of formulaic. Different violations have different fines. And so if someone were willing to accept that, then they could just go forward, not have a judge. And that would free up bench officers to do the work where AI doesn't really even have a role, which is to be in treatment court. So my last 8 years on the Santa Clara County Superior Court, where I served for 24 and a half before retiring, was in treatment court, where it's all about the person. It's about their mental health concerns. It's about their addiction. It's about their homelessness situation. It's about their children. And those are things that AI just doesn't have a role in right now. And the judge needs to be there to gauge the human being and to connect them to services. So if we don't have enough judges and we don't have enough resources, why not think about ways to have certain case types at least initially kind of screened by AI, and if the litigants accept the outcome or the fine, have that go forward. So we're freeing up court staff and judges to do the work that really requires the human being, not just in the loop, but solely dedicated. So I think there's definitely some room for that. I said this first at Loyola Law School when we do the National Center does a training for media people, and I think it was sort of like radical, but I definitely think that there's a way to do that. And then in terms of AI supplanting the judge's sort of thought process and analysis, the judging piece, I think that won't happen because judges shouldn't and won't let it happen. For 9 years, I served in the California Commission on Judicial Performance and was its chair, and that is one of the first disciplinary bodies in the nation. All other states now have a disciplinary body for judges, and they're based on California's. And so the canons of judicial ethics require the judge to be diligent and to make that deliberative process. And that's why Judge Munoz, in the case that Judge Campos cited, Campos versus Munoz, which isn't any relation, and the parties were named Munoz, and the judge was named Munoz, so there was no relation. That's why the appellate court came down so harshly on Judge Munoz, because, yes, the family law assignment is really busy. Yes, you see so many cases. Yes, the lawyers stipulated, but still the judge is ethically required to do that work that is the judging. And if not, they may be disciplined and even lose their jobs.
Those are terrific points. And I especially agree with the idea that, where judges are engaged in formulaic or deterministic roles, it makes sense to free up their resources where they can be more value added in human-centered roles. It's a great point. Judge Campos?
I've got a few things to say, and you won't be the only radical. I'll be radical. Okay. First of all, Erica served, and thank you for your service, on the commission that gets judges in trouble. And I got to tell you,
judges get in trouble, and then they get to the
sorry,
commission.
I apologize. Can we see how I'm already taking a different perspective here? Judges can be reprimanded and reported by your own court staff, by anyone who walks in the door in your public courthouse, and any litigant that's unhappy with what they got. There's so many reasons that judges can get in trouble that I think we're going to get AI judges, because you're not going to find too many humans that can do the job competently, that want to do the job, because of the lack of resources and the stressors that are just unbelievable. So that's my first radical point. My second radical point is that when I first took an evidence for judges class almost 23 years ago, they asked a question about how we would rule. Half the class raised their hand for sustain, half the class raised their hand for overrule. And I was sitting there thinking, wow, how can this be? Well, it can be because for any judicial question, there's a range. And unless you step outside of the range and commit abuse of discretion, you've got some leeway, okay? Anybody who's litigated trials or appeals knows that you can find facts that favor one thing, you can omit facts that may, do another thing. And so there's a lot of flexibility in the tail end judging. My third radical point is that, yes, treatment courts are wonderful. I was trained in drug court and therapeutic jurisprudence over 20 years ago, but I think that we are wasting money in the state judiciary by focusing on one-on-one retail when we have much bigger institutional systemic problems. And then the fourth point I want to make is that you have no idea how many self-represented litigants we have in a state like California. People cannot afford a lawyer. And our state has been developing basically litigate by, connect the dots, all of the judicial counsel forms. You're supposed to be able to look at them, fill them out, and process your own stuff. And even then, it doesn't work real well, because the procedural points, the paperwork points, the when do you have to file this piece of paper versus that piece of paper, whether it's electronic or actual paper, that's been a system that's been made up by administrative staff. It's not judicial written or driven, because in the courts, we have a split. Judges do the judging, and then we have an entire branch of employees that are run by executive officers. Okay. And on self-represented litigants, I've had matters where people have used their GPTs or other stuff. And I'll give you an example. Had somebody that thought that they could just go in and take over somebody's vacant looking house because they had received an answer on adverse possession. Okay. And it's good law. Adverse possession is good law. Except that if you're only asking one question and you don't know enough to ask the other question about, will I get in trouble? And it won't tell you on its own about criminal trespass or burglary charges. What have we got?
Sorry, is anyone here from Florida? So Florida is using AI in a great way to give self-represented litigants access and using the forms. They have a chat bot who speaks Spanish, English, and the native tongue, and it walks them through the documents. And so that's an example where in that state, AI is really helping in terms of access. There's a bunch of examples on the National Center for State Courts website. So yeah, we're not a perfect system, but I'm really excited about what AI can do in terms of helping litigants who cannot afford an attorney.
Yeah, thank you. And I just want to call out Professor Engstrom's research, where his research showed that some huge percentage of pro se litigants, when they look at their cases, they would have won on the merits, but they lost either by default or for some technical reason. And AI can help in that area. All right, let's shift our focus to deepfakes. And I know, Judge Yu, that's something you've thought about. And as we've said, we've had two problems with deepfakes. One is deepfake evidence. There's been a few cases now where litigants have submitted actual fake videos and have been caught submitting that, fabricated audio, video. And then we also have the opposite case where lawyers are casting doubt on genuine evidence by implying to the jury that it's actually a deepfake when it's actually genuine. So first, I want to ask you, how are judges supposed to handle this? Are our rules outdated for evidence? What should we do?
Okay, so just pausing on what you said, you're talking about the liar's dividend, where because everyone is thinking everything is fake, then even something authentic will not be viewed as authentic. And so that is an offshoot of the consequence of deepfake evidence. But what are judges to do? So I'm going to back up and talk about the fact that we have really good tools now, and I believe in the rules of evidence, California, the FRE. There's a movement to possibly modify the FRE, Evidence Code 902, but definitely we have tools that work, and I'll explain why. But I also want to say that for centuries, courts and litigants and lawyers have dealt with fraudulent evidence, right? A check may be, kited, or there might be something that was faked and that provided to the court, and somehow someone had to determine whether that was legitimate or not. And so the rules of evidence will work. There's two types of evidence that are generated by AI, and there's two different bench cards for all of us, for judges and for lawyers, on the National Center for State Court website. So the first one is ones that we've dealt with before. That's where the work of AI is acknowledged. It could be a reconstruction video from an accident. It could be, a photograph that was enhanced. Everyone knows it's AI. Everyone agrees about it. And then the question is, did this change the authenticity of the video? Is this something that is reliable? Should we show it to the jury? Is it for the proof of the matter stated, or is it just a demonstrative? So that is pretty much something we've dealt with as lawyers. We look at, if there's an expert generated a document or some scientific thing, we're looking at Daubert, we're looking at expert rules. So the next issue is really more the deep fakes. That is where probably not the lawyer, but the lawyer's client generated some piece of evidence, and the lawyer may not know that it's faked. And so that the rules that we talked about with the ABA and the California State Bar really come to play for you as attorneys, if you're attorneys in this room, of your obligation to ask the questions in the bench card to talk about, well, where, client, did you get this? What's the chain of custody? Has this been modified? Is there corroborating evidence before you proffer that to the court? If you proffer it to the court and it's determined to be faked, there may be held to pay, or, there may be consequences for the judge, for the lawyer, but if not, there could also be really significant consequences for the case. And one case that I think you're alluding to comes out of Alameda Superior Court, where Judge Kolakowski, whom we both know, was, had a case where the plaintiffs were self-represented litigants suing Cushman Wakefield. And what they said they were doing is they had a witness who wasn't available, so they had basically a video of someone saying the words of the witness. I think it was the witness, but the mouth wasn't, meshing. And the video is actually on the National Center for State Courts. So you can watch this faked video. And the judge actually ended up dismissing the plaintiff's case as a sanction for the fact that they repeatedly were submitting faked evidence. So going back to do we have the tools? I think we do, because when you look at admissibility, you're looking at relevance. Is this piece of evidence relevant? And if relevant, does the relevance outweigh the prejudicial value or if it like probative versus prejudicial? Maybe we know that this is something that may not have been authenticated as an original document, but it's been somehow modified. And your question is, as a judge, is this relevant? Once it gets to relevant, the more interesting question is this going to be reliable evidence? And that's all those questions about chain of title. For me, what I think is the biggest concern, because I do think that the court can kind of sort it out, is that two things. First, that the technology to create a deepfake is getting better and better. And then the second thing is bootstrapping. So when the technology of this, of changing a photograph or a video or a document is getting better and better, it could be that there's no way that a self-represented litigant can figure out how to express that to the court. If you're an attorney and you have a well-heeled client, you could probably hire an expert. And there's still, at this point, we can look at metadata or other things, whether there's a blockchain behind this document, to determine whether it's reliable. So the lawyers and the experts can help the court. But self-represented litigants don't have that capacity to necessarily understand, to express to the court the concern, or the funds to hire an expert. And so I think at some point the courts may need to partner with universities or experts to have a bank of people that can be there if needed, to be called upon to advise the court if this is something that's reliable or not. And we do have models for that right now. So the courts in family law cases have, therapists who can, or court facilitators who can talk to the child and interview the child for the judge, because the judge can't do their own independent evidence. That would be ex parte and violative of our ethical canons. In criminal law, there's a bank of experts who can do capacity evaluation for judges to determine, did this defendant have the capacity to understand what they were doing? So maybe we need a bank of people who would be available as experts to advise the court if the court needs to know if this is something that is authentic or created. And I think, different courts have judicial councils. It might be a place where those experts would be situated. My concern is the bootstrapping, because it could be that someone wanted to, fake title to a piece of property. You could fake that and take that to a county recording office, and the county employee is not someone who's necessarily steeped in what we're talking about. They could stamp it, and then that document could be proffered to the court, because there is a class of documents that are considered to be inherently reliable. It used to be newspaper articles, right? They could come in as inherently reliable. I don't think that could happen nowadays. Documents that were filed with the county agency that are certified. So there's really a lot of room for mischief, I think, and concerns that the court is going to have to grapple with. And it may be that the lawyer may have gotten that from the county clerk. The parties may not even know that it's generated by AI. So there's a lot to think about. It's an exciting time to practice. I'm kind of glad I retired at this time. But there's a lot to think about. It's really exciting.
And can I just follow up a little bit with the other side of the coin, which is the ethical duties about implying or suggesting that genuine evidence is deep fake and the undermining of the trust. Can you say a little bit more about your thoughts on that?
Yeah, so lawyers are court officers. They do have an obligation to be truthful to the court. But, you're also advocates. You have an obligation to the client. And so if you're going to make an argument that something isn't reliable, that's arguments that people have made all the time, right, to test that burden of proof. And so I think it's going to be a case-by-case basis, and really sort of the depth of what that piece of evidence is. But ultimately, the lawyer is going to have to be guided by the canons that they must adhere to.
And I've seen suggestions that they amend the canons to add a rule against unreasonably arguing that something is a deepfake unless you have a reasonable belief for making that. What do you think about?
Well, and that's one thing I've talked about before, which is I think the rules of evidence still work, but I think we have to look at jury instructions. I think the jury instructions need to be modified to account for things like that. Along with the rules for lawyers in their professional practice, definitely I think there's room for modification of jury instructions. And there is a jury instruction that a judge wrote that he used AI to write to explain to the jury what is AI and what weight you should put on things.
Oh, thank you. Judge Campos, do you have a view on deepfakes?
I'm not here to be Debbie Downer, and I'm going to end on a positive note before we close this whole thing out. I just think that this all sounds great, but the nitty-gritty reality, if you walk into any state courthouse, is just a flood of humanity and a flood of experts who do work for us, but who are so overworked, overwhelmed, underpaid, and understaffed just on the mental competency front, because the jails and prisons have become the de facto mental hospitals that existed in our state before Camarillo State Hospital became Cal State University Channel Islands. And so again, I think that we can say all these great things, but we're missing the point, and we're missing what is right in front of us in terms of most obvious. Now, courts did get required by the statewide bodies to come up with policies if they were going to allow AI. And courts had to do that by mid-December of last year. My position was and is that Federal Rule of Civil Procedure 11, Rule 11, it already governs your liability as someone who signs any kind of pleading, and that alone should have covered it. The statewide equivalent is California Code of Civil Procedure Section 128.7, which was modeled after Rule 11. So I have a different point of view. I don't think that our evidence rules are enough right now. You can admit a photo. It can be fake, but you can admit a photo if you basically have the 4 questions that are generally asked under evidentiary foundations. Look at what M. Wrinkleread writes about on either the state or federal side. What is this? Do you recognize it? Is it in substantially the same or similar condition as when you saw it back then? Yes, yes, yes. Okay, move to admitted. And the volume of lies that already exist in the court system are just going to multiply exponentially when the smarter, savvier criminals that exist are going to just be putting things through the court system that there is no way an individual jurist who cannot even get through their own calendars as it is now is going to have time to parse out any of this. There's no way that there's going to be financial resources to check out experts on any side, especially for all the self-represented litigants. And so I kind of have a different viewpoint from my life experience and my 22 plus years in the trenches. And I will tell you that traffic, small claims, unlawful detainer, other things can be vastly assisted for self-represented litigants through AI, as I see it. My positive point is going to be that there are a lot of wonderful judges doing their best to try to work on this. I'm part of what's known as JAIC, which is JAIC, the Judicial AI Consortium. And this is a self-funded group that's been pulled together by a Louisiana appellate judge and by a U.S. magistrate judge in Denver. And so judges across the state are getting together independently on their own time during their own lunch hours to try to bounce ideas, to try to figure this out. But I would just request that the policy folks actually spend a day in the trenches and try to do what the day-to-day judges in the trenches are being asked to do. Because you're going to have a real different perspective and a real different experience because the volume, certain assignments, not all assignments are equal. Not all judges are equal. Some people get hammered with the really unsexy, unglamorous, nitty-gritty, and those folks are drowning and have been drowning for years. And then other folks get the great assignments and the assignments where, things are peachy and everything's wonderful and you're not all stressed out and your car's not there at 9 o'clock in the parking lot when you've got to be back the following morning. So there's all sorts of things out there. I do believe in RoboJudge. I do believe in using this technology for access to justice. But we do have to make some institutional changes, and we have to teach people that AI is not intelligent. I don't think that many lawyers or judges in the general population, you folks are exceptional, and this doesn't apply to you, but I don't think that folks in the general professional population understand that it is predictive word selection. And for whatever reason, that just gets lost. And so I think that people expect different things out of anything you call AI, and that's why they freak out about, is the AI going to replace the judge?
I think some of the people in the room know Judge Scott Schlegel, the judge from Louisiana. He's amazing and has worked with the National Center. And I think where there is a will, there is a way. It may not be touching every court now, but the way is people are looking at it at the National Center with the consortium, with TRI.
Says my retired judicial colleague.
Yes, who was happy I retired at this time.
Yes. Well, Judge Campos, one point you made I really want to emphasize is AI is dealing a lot with the symptoms, and it's not dealing so much with the underlying problems, underlying institutional problems. AI is kind of a Band-Aid, and I think it's really important to reflect on that and make sure we don't stop working on the underlying institutional problems.
Excellent point.
Yeah.
Excellent point.
Thank you. Shlomo, do you have a comment on deepfakes? Some have suggested a technological solution. For example, some modern video cameras take fingerprints of the video and you can, cryptographically ensure that it hasn't been altered and it was produced by the camera at a certain time. That's a very small percentage of modern cameras. Things. Is there a technological approach to any of this?
Yeah. My technology, which is the only thing I really feel confident speaking about, we don't touch deepfakes. I've seen a lot of the technology. It could, because that would be a great add-on technology. It's like, not only can we help you analyze your case, we can help you be kind of like an antivirus for courts, which is what we're doing with some courts with catching hallucinations that the current hallucination tools don't catch. It's a cat and mouse game where the tech is advancing so fast that the deepfakes are getting so good is that the deepfake detection has struggled to catch up. Maybe that will change in the year. But I haven't seen the technology getting so good. Can I comment on the last thing you said though? Because it is important to focus on the root causes, but those have been in existence for 100 years. They will not be solved in the next 100 years. There's reasons of political economy. There's reasons of the guild of lawyers. We are not getting more judges. We are not getting more staff attorneys, and we're having an intense. We're going to have courts are already flooded by litigation, and it's going to be even more so now. What's urgent now is having the right tools, not just anything you put AI onto, but something that's purposeful for courts to actually solve these fundamental problems. That is the only, in my view, that is the only. We've talked a lot about how these problems are urgent, and being able to have trusted tools that are vetted by courts and that are architected for epistemic humility and for accuracy, I think are the only ways of doing this. Otherwise, we're going to be here in 20 years talking about the same issues.
Yeah, those are some great points. And two, I want to emphasize. First is the famous unreliability of AI detectors. So as a professor, I know this well. We get marketed, are your students using AI? Huge false positive rate. They're not reliable. I just want to... Don't believe that. And then the second, and I feel the same thing for probably for deepfake detectors in court are not going to be reliable anytime soon.
It's worse for images because those are more photorealistic. I mean, for a text detector, you could just say any text before 2022 is not generated by AI and you have a good other sample. But for images, it's much more difficult.
And then your second point, which I agree with, is let's not make the perfect be the enemy of the good, right? If we're not able to solve these systemic problems, at least this is better in many respects than the alternative. Speaking of being better, let's end on a positive note. What are our hopes and promises for AI in the courtroom? I'll start with Judge Yu.
I think the hopes and promises in the courtroom are really, right now, primarily focused for self-represented litigants. There's just so much out there that courts are exploring, like the Florida chatbot, just all the different things, including, there's videos now on how people can serve a party, where they should stand in court. A lot of those videos are generated by AI. So I think in terms of someone who cannot afford an attorney because they either make too much or they just don't make enough, where they have to take time off work, where they're having to the court's determining where their child's going to live, if they're going to have custody of the child, if their business is going to survive, and they're on the edge of surviving. I think that the AI tools that they will be able to use will make a huge difference to them. And also, I have been in the situation where I've gotten things from inmates or self-represented litigants where it's written on pencil and binder paper or on a judicial council form in pen and a handwriting I can't read. Now they're, using AI to at least put things in text, so it's clear what they're trying to say, and then you can save time in terms of talking to them and delving deeper. So I think that's an area that's going to be really a huge boon and benefit to our populace.
That's great. And a shout out to Stanford Law School for helping implement these changes for pro se litigants. Judge Kempas, what's your positive view?
My positive view is that I love now when I have to do instantaneous performance exams on issues that pop up on my cases, that I can use other tools, whether it's co-counsel, whether it's anything off my phone in terms of just quick and dirty. I always have a sense of where things are going to land, but I need it to find me a case, and I'll ask the lawyers, give me your best case. I go to the Westlaw, I print it out, I read it. But now that I can even do more quick and dirty thanks to the AI tools is fabulous.
Okay, so it's really helping you kind of gain a little more control than you felt like you had before?
It's helping me try to ensure that I'm getting the legally correct answer. There's so many other things that go into the judging part in terms of, did the person feel heard? Did they see did I get eye contact with them? There's just so much other stuff going on that I try to focus on. At least I want to try to get the law right.
Okay, so what I love about that is there's so much focus on AI mistakes, and there's less focus on AI improving quality. And that's because nobody complains when they have a higher quality, brief that comes in, but it's easy to see the other side. So I love that you're emphasizing how it's improving the quality. Shlomo?
I'll tell you a story. I was speaking with the chief executive officer of a major U.S. court, and he said, I've dedicated my entire life to the court system, but I would never want to go into it. In fact, Learned Hand himself said he fears a lawsuit more than he fears death. My goal is to change that and to build a court system that is worthy of the American people and of the justice system. And to channel James Carville and Bill Clinton, I think that there's nothing wrong with the courts that can't be fixed with what's right with the courts. And with the right technology, I think we can build the system that we all would like to see.
Great.
Can I just say that the role of lawyers and anyone related to the legal profession is to tell your relatives, neighbors, friends about the good. Because there's so much institutional distrust in everything. And even now the court systems have lost their position in terms of people being able to trust them. So your job is you are advocates for what is the good and what works. You are the advocates for explaining what does the rule of law mean, because the general population really has lost a lot of faith in our institutions, and they're not going to get it back unless they hear from someone they trust, i.e. you all. So please do that work.
Well, I'm going to agree with Judge Campos. Yay.
Yeah.
High five.
Because the courts have been under attack. There's information that Complaints against judges, threats against judges have on federal system have gone up 400%. Judges have lost their lives. They're being doxxed. Their children are being doxxed, so that people know, like the judges now know, okay, now I know you know where my kid lives, and you're sending up pizza to them in the name of Judge Salas's son, who was murdered at her house. So lawyers are great partners with judges in upholding all that's good about our democracy, which is our court system. The third branch of government is going to be the line of defense for our democracy. So I definitely agree with Judge Campos.
I'm so glad we agree.
And I've been told we have time for 2 questions. Any questions from the audience? There's, if you have a question, please stand up at the microphone. All right, I think our 2 questions are taken. All right, over here.
Hi, thanks so much for speaking. This is a fascinating panel. I work in technology, and I'm skeptical of technology, but I have hope in the legal system and the judicial system. Is there a societal penalty or approach to go about this to solve a technological problem? It felt like a lot of these solutions should be coming from technology, but my hope from the outside is maybe there's, for example, like when I was in college, we didn't have ChatGPT, but if I cheated on my exam, I would have probably gotten suspended or expelled. So I did not cheat on my exams. Could you have situations set up such as that rely on societal or ethical considerations that cause people to do better stuff rather than having to police the hallucinations from a technological perspective?
I think that, if it's okay if I jump in, it's definitely the sanctions that courts have available to them. There's evidence sanctions that you can't present evidence on this. You can dismiss an entire case. You can report a lawyer to the state bar. They can be sanctioned. There's multiple different tools that the courts have to try to motivate people to keep them honest.
I will just say that, yes, we have all these tools, but there's always a cost-benefit analysis in my mind. I deal with so many people. I try not to personalize it. I don't want somebody deciding that they've been antagonized by me and that they want to come after me, because these are some real life and death issues. And so I try to, keep it light. I've never sanctioned a lawyer, although I could have a number of times. Why didn't I sanction the lawyer? Because I knew that reciprocally they would send me to the Commission on Judicial Performance, whether it was valid or not. And I didn't want that headache. And so I've adopted the, philosophy of have a lot of grace and believe in karma.
And I just want to add there's only so much sanctions can do. And part of the other problem is rebuilding social norms and institutional trust so that people want to do the right thing. So, educating our students, the next generation, not to want to make threats, not to want to cheat, not just out of fear of the sanctions, but because it's the right thing to do.
Hi, real quick. I think Americans should be far more proud of the Sixth Amendment. And with that in mind, what are your thoughts on AI and deliberations, either in the present, the future, the both in general? Thank you.
Can you say a little bit more about what you're thinking?
So jury trials,
Yeah.
right? Uniquely American. And if we're all using thought aids to make decisions in our daily life, even judges, we're excluding that from the deliberation room. And I think for good reason right now, but maybe in the future. So just your thoughts generally.
So one of the things I used to always tell my panels when I was selecting a jury, and I'm not sure how much time we have, was that, our country is so lucky, as you said, to have the process of jury trials. We came from a country where people could be thrown in prison by a king and not even know why. And I said that it wasn't until modifications occurred that jurors were only comprised of white men, and then people of color could become jurors. But it wasn't until 1972 that the United States Supreme Court overturned a case from Florida, glad no one's here from Florida now, that said that women were better suited to make decisions inside the home than outside the home. And so I would tell the jurors, the potential jurors, the veneer, it's not just your duty to serve, it's your right. And people fought hard for everyone here in this room to be on that jury. And so I really have so much trust with the jury system. Talk about sort of motivating them to work to their higher selves. I have so many jurors because I plied them with chocolate and food, but they would hug me at the end and they would say, you made us better than ourselves. And so I definitely think that that's possible. I'm not sure, in my mind, where we could allow them to use AI, because we don't want them to have ex parte processes. If it is to be used in the future, it has to be where the lawyers and the litigants all know about it, they agree, and there are certain parameters so that the people don't go outside to a different platform to get a different answer. Right now, it's not happening because it's just not controllable, and some judges take people's phone and put it in a basket because they can't even, okay, I disagree, I don't do that. But, there's different people who don't even let them have their phones as judges. But it's interesting to think about it, I can envision a case where if everyone agrees that they would be able to use a certain tool in the deliberation room. It's a great question because it's a great reminder of how special we are as a country that we have jury trials.
Can I jump in?
Yes, please.
I think from my experience of doing this and having been a trial lawyer and assistant United States attorney, I think that juries generally get it right. They try really hard. Where I see miscarriages of justice in terms of results I don't agree with, it's when you've got mismatched counsel, when you've got a newbie and someone very experienced. So I would not want anything inside of the jury room other than the humans. I take their phones away. I took their phones away. I still will take their phones away. I started doing that when smartphones came out. I didn't want them surfing the internet. I didn't want them shopping instead of deliberating. And I didn't want them Googling. Starting off with Ask Jeeves is when I took the phones away. Okay, who remembers Ask Jeeves? So, I took the phones away. No temptation. It's all good.
Well, please join me in thanking our excellent panel for a fantastic discussion. Thank you. Yes.